Hey everyone, welcome. It's David Brannen. We're here for another edition of Ask a Lawyer Live. Today is our employment edition, and I will be covering an employment topic. Let's take a peek at what we're talking about today. So today we're going to be talking about something that almost everyone has some interest in, just because people like to know what you can do around this topic, and that is secretly recording your coworkers and employers at work. We will often have people approach us who have already done secret recordings, or sometimes people will ask us whether they should, but more often than not, people will come to us saying, I've recorded this, I've got this from my coworker, I've recorded my employer saying something. And this can present a lot of problems in a case. There are times when recording is good and when it's bad. Let's go through it. And sometimes where it's illegal. So let's go through all of it here. So smartphones, everyone has one of these in their pocket, and it's very easy to just put it on record and slip it in your pocket, or even have it sitting on the table recording. So it makes it very easy to record others, and they don't know that you're doing it. Now, just because you can record doesn't always mean you should. We'll talk about here in this presentation when it's legal to record and how it applies to employment law, and when doing these kind of recordings can come back to bite you or haunt you, however you like to say that. Now, first of all, is secret recording legal in Canada? I get that question asked a lot by people in almost every, whether it's disability claims, employment claims, or just people who are interested to know. Yes, secretly recording in Canada is not illegal under our criminal code, as long as you are one of the people in the actual conversation. It's called a one-party consent system. So as long as you are part of the conversation that you're recording, you are going to be okay, because you are consenting to the recording and you are part of the conversation. Where it becomes a problem is when it becomes a crime is when you are not part of the conversation and you record it. That's wiretapping is the common word that is used, and it is illegal. So leaving a phone in a meeting that you are not a part of, or secretly leaving your phone somewhere to pick up a conversation in the room when you're not there, that is considered wiretapping or bugging a room. It is illegal, and it can get you in a lot of trouble. Could be criminal trouble. Again, it's an area that has a lot of textures to it, but worst case scenario, you can have criminal charges for that kind of thing. Now, just because it's legal, so we know that you can legally record a conversation that you're a part of, even if the other person or persons don't know. But just because it's legal doesn't mean there won't be negative consequences for you. Employers often have policies against doing these kind of secret recordings in the workplace. And even if they don't have a policy prohibiting it in the workplace, doing so can be seen as dishonest or a breach of trust with your employer, and has been used as justification for terminating people for cause. So doing these types of recordings, even though it's illegal, can still result in you being terminated from your employment for cause, which means you wouldn't receive notice or any type of severance pay. Now, can these recordings be used in court? Because that's usually why you're doing them. You want to be able to have them as evidence of wrongdoing by other people. And the answer to that is yes, they can be used in court. as long as they were legally made. So if you're the one doing the recording in the conversation, but again, just because you can do it doesn't mean you should. Judges pretty universally in Canada do not like secret recordings. It will hurt your credibility. It will make you seem like more of a dishonest person. And more often than not, these types of recordings backfire for you by not helping you, but can hurt you. So judges don't like gotcha type of evidence, even if you catch people somewhat in a lie. If you go about it in this type of manner, they do not like that kind of evidence. So it just can rub off poorly on you and can hurt your case just because it makes you look dishonest. And the case law, like the judicial decisions, but the judicial decisions that the judges put out over this, they are universally condemning this. There are cases where judges will say, okay, yes, we can understand that it is. There are cases where a judge will say it was justified and valid to do, but overwhelmingly they will condemn it. So just keep that in mind. Now, what about recording your employer? Well, they will look at the context of this. So a court will look at the context of the recording, and that is what's most important here. So if you're just recording because you don't trust the employer, that is probably not going to be seen as a good reason, and it will justify as a breakdown in the relationship. And courts in those cases have upheld people being terminated for cause for doing this type of thing. Especially if you've hidden it for months, the fact that you did these recordings and only bring them to light later on, like that, it can even aggravate the whole situation. So what you don't want to do is spring these on your lawyer who you haven't told you have them, and later on tell that, like, that will probably result in the lawyer withdrawing as your lawyer, and you'll be without a lawyer if you do something like that. So if you have these types of recordings, you must tell your lawyer up front about them. You can't hang on to them and spring them out later on. You'll have a very angry lawyer in that situation because it reflects poorly on the lawyer, can get the lawyer in ethical trouble. And so that will result in the lawyer leaving your case for sure. Now, there are times when courts have said this is appropriate that you have done this recording. Often this will happen in human rights cases or harassment cases where it's very difficult to otherwise prove the discrimination or harassing behavior. And you will find, like, the cases where courts have been understanding and agreed that this was good evidence to bring were in these types of situations. So that is something to keep in mind. If you've got an unsafe workplace or a toxic workplace, or there's no other way to prove the actual discrimination is happening because it's not written down and that kind of thing. But even in those cases, it can be risky. It can still be very risky because what you perceive as harassment or discrimination, etc., a judge may not agree with you, and you may feel like you were justified in doing it, but it won't be seen that way. This is why it's very critical to get legal advice first before you go do these. It's common for people, you're wrapped up in your situation, you're going to have a certain perception of it, but that perception you have may not be agreed with by other people. So it's important to get a lawyer to look at this and give you some sense. Is a judge going to agree that this is the kind of harassment situation where it would make sense to do a secret recording? That is critical to have that advice from a lawyer before you go do it. Now, termination. The risks of actually secretly recording your employer. Well, there's a few of them here. So termination for cause is one of the biggest risks. So you're going to be a situation where you're fired. You might breach company confidentiality. That is a huge one. So that is also a reason you could be fired or sued by the employer. You could lose credibility in court. This will almost certainly happen if you do a recording without getting legal advice that it was right to do, because almost all situations of these recordings, they do not come off well. And it's the rare situation where they actually help you. And it could, like I said, you could get sued by the employer over sensitive information and that kind of thing. So then that has happened in Canada. So just be aware of, there's a lot of risks of doing this, and you should not do it lightly. Now, what should you do instead of secret recordings? So there's a bunch of things that are better than doing secret recordings. Simply keeping written records or emails that you've received. So keep any paper documents that can help prove your case. Or if you have a conversation where there's things said to you, keep a journal where you record it down, what was said, the date, and record it at the time, so that months later you can say, this is what I wrote down on that date. That will be more credible than having a recording, even though you could say, well, I could have made it up. But again, judges do not like these secret recordings. So they will look more favorably upon you if you keep notes like that than if you have a secret recording. You should, instead of doing secret recordings, you should raise issues through HR first and bring all the issues to light and let that process play out. Absolutely get advice from a lawyer before you do secret recordings to ensure that this is going to be a situation where this will not come back to backfire on you later on. Because once you do a secret recording, you have to disclose it later on. You're not allowed to keep it secret. And so it's not like you could do the recording and then later learn, oh, I shouldn't have did that, so I'll just destroy it. Like, once you start a lawsuit, you have to produce all evidence that you have, including these secret recordings. Finally, instead of doing a secret recording, just tell the person that you're going to record the interaction. Now, obviously, that could totally defeat the purpose in some cases, but in other situations, it can serve a purpose. If you just want a record of what was said and what was done, then that will do it. It definitely will affect people. If they know they're being recorded, they're not going to say certain things. They're certainly not going to harass you and that kind of thing. So again, better to openly record, but if in the right situation, there's no choice but to do a secret recording. So just to summarize when it could be justified, it's going to be situations where you've exhausted all other options to try to get evidence to prove the poor behavior that you're dealing with. It would have to be a situation where a court would agree that there's no other way to prove serious misconduct. And again, the emphasis there would be on a court would agree with you that there's no other way to prove it. If you feel unsafe, and again, that's a very subjective feeling. So again, consult a lawyer to see if your feeling of unsafety is going to be justified in doing a secret recording, but that could be a reason. And obviously, if you've consulted a lawyer and they tell you that this is a good situation to do a secret recording, then that would be a time to do it. Now, in Canada, one party consent, to just wrap this all up, one party consent in Canada means that secret recordings are legal as long as you are part of the conversation, but they can carry serious consequences for you if you do them in the context of work. You want to think very strategically about yourself and the right to protect yourself and go about this the right way. Always get legal advice before doing secret recordings. I cannot state that enough because of how much these can backfire and really hurt your case. Now, if you need help, you can always contact us for a free consultation, and you can download books from our website, and also the links are down in the description here. And if all else fails, just like I said, book us for a consultation and we can chat over with you for your situation, or you can ask questions here at Ask a Lawyer Live every week by typing in your questions, or on Thursdays. Tomorrow I do a call-in show where you can phone in and ask questions over the phone. All right. So that's it for recording. I'm not sure if anyone watching has recorded someone at work. What your thoughts are on that. Like I said, we've had people come to us who are absolutely convinced that the recording they have is like smoking gun evidence. And I have to tell them, like, no, it is not. And not only that, like, this really hurts your credibility that you would have recorded this person. Unless it is such an extreme situation and you have really exhausted all efforts, it will just get sympathy for the other side that they were being secretly recorded. So you have to be very careful about it. I really would encourage you not to do it. Same thing if you're in the context of a long-term disability claim. You shouldn't secretly record your doctors, your lawyer, or others. It will just result in a lot of problems. You're better off doing open recordings. If you're going to a doctor, you're going to talk with your lawyer, you can always ask them that you want to record it just so you have a good record of what was said. That's usually they're going to agree with that. Some doctors won't agree depending on the situation, but better to do open recordings in those situations than to secretly record. All right, I'll give it some time here to see if people have questions. I will also dive back into, I've been taking time on these calls to answer questions on the forum, the Resolute Legal forum. So I will take a see here if we have any. Wow, I'm all caught up. Can't believe it. I cannot believe it. Oh, there might be one question here I could talk about. Let's see. Yeah, there's a question here I can go over. Let me just share my screen. There we go. So here's a question about grave conditions. So when you apply for CPP disability, you can actually, there's two submissions that you can make. You can make a regular application, or you can make an application by designating your situation as a grave condition. If you have a designation as a grave condition and Service Canada accepts that you meet the criteria for that, then they process your application much faster. And this person is recounting a situation where they applied and got a denial within 4 weeks. And they wanted, like, that is pretty fast. So if you apply and get a denial in 4 weeks, usually it takes like 6 months or more, 6 to 7 months. This person's saying when they called about the application, they're saying it had been marked as grave. Now, this person is saying that even though I have a grave condition, they still denied my application, which can seem kind of a little bit counterintuitive. A grave condition, I don't have it right in front of me, but my understanding is the definition of that. There's a list of conditions that count as grave conditions, and they have to be a situation where that you have a limitation on your life, like that you could be passing away within the next 6 months, that kind of thing. So the grave condition does not always mean that just because you have a grave condition does not mean that you will automatically meet the definition of disability. So what does it actually mean for Service Canada to have a grave condition? Let me see if I can find it and just bring it up, actually. I may have the list right here. Yeah. To have a grave condition, it must be indicated on your medical report. And I'm going to show you where. So when your doctor is filling out your CPP medical report, they have to indicate that it is a grave condition. Let me double check here. So there is a list of grave conditions, and I'll just share a different screen here. Just 1 second. Oops, I don't want to share screen. I want to upload something. Here we go. Hold on. All right. So this is the doctor's form for CPP disability. It's just uploading here now. Just give me 1 second. Here it is. So this is the doctor's report. Whoops. There we go. Grave conditions are right. They're mentioned here at the back, right there. So there's a list of grave conditions. And you can see they cover a lot of different things. And the whole point of a grave condition, it's kind of explained right here. Let me I got too much going on my computer here. It says, these conditions with marked and severe Functional limitations have a high probability of meeting the CPP disability eligibility criteria and may result in death. Now, this is not an exhaustive list, but they're saying these are ones that Service Canada recognizes as grave conditions. And I think grave condition is also indicated on your application. There's a grave condition. There's actually a separate application form for grave conditions. So there's slightly different questions on that application form if you put in that you have that you're dealing with a grave condition. So this person wants to know, like, any tips. Oops, I got the wrong screen up here. This person wanted to know, like, any tips on what they could do. So you would treat it just like any other CPP application. You would still have to prove you have a severe and prolonged disability. Oh, there we go. So you still have to prove you have a severe and prolonged disability. Yeah, people are just posting the things. Yeah, this person wants to know why. This person could simply have applied with there's two application forms, and it's possible they just applied using the grave application form and not realizing it. That's probably what happened here. That's probably what happened. I'm just going to put a reply here. So I'm just going to put grave condition applications for CPP disability. This is just a guess, but maybe you filled out that form that you filled out. Actually, you submitted. I don't know. It might not be. I don't want to burrow into this person's details, but that could be what happened there. So just a guess. There we go. Okay. Whoops, I stopped sharing. Let me try that to get that back. Here we go. There we go. Let's see if we got any other questions here we can answer. A lot of these I've already covered. Okay, so this one is T4AP CPP disability and taxes. What's this all about? I've been on LTD through Manulife. I was urged to apply for CPP disability. Yep, which I did. Approved. Manulife received a large sum of a retroactive payment, not me, but the T4AP. Yeah, the T4A was sent to me in my name. So it shows I made $23,000 more than I actually did. I spoke to CRA and they said I need to fill out line 22,900. That's the amount to offset. Yeah. But I cannot find this line while doing my taxes. Yeah, I always said it was a different line. It's the line that I say in my little CPP disability book here. Whoops, this book here. It talks, there's a whole chapter, or not a chapter, but a section dealing with these taxes. I have 23,200, line 23,200. I don't know where they got 22,900. Is that even a line? That's other employment expenses. Yeah, that's not the right line. I don't think that's the right line. I think the right line is 22,300. So, I mean, I'm not going to go against a CRA. I don't know who this person spoke to at CRA, but my understanding it is not line 22,900. That's for other employment expenses. That is not the right one. You add T2200 to your tax file. Here, I'm going to reply. Report this payment to the employer. This payment from actually, I'll just make this simple. At what is it? 23. It's at 23. 23,200. Yeah, there it is right there. So it's 20 at 23,200. Page 94 to 97 of my book. There we go. Should probably put a link in there to the book. Let's go see. There we go. There we go. All righty. Checks here. Someone has any? Nope, no questions. That's a pretty easy one to figure out. Let's check another one here. What's this one here? Disability tax credit. Really sorry, I have a dumb question, but the doctor has me confused. I'm looking for clarity. What would happen if you answered no? Do not adjust my previous tax returns at this time. What happens if you answer yes? I would like to receive any credit I'm eligible for. What is the correct option to choose? Well, yes, you want them to adjust your previous tax returns because that's how you get the refund owing. Yeah, I'm gonna love this one. Caro's got it right here. Yeah. So I guess if you ask the government to do it, they'll just apply this. It says here this person had other amendments they wanted to make, so they said no because they wanted to do it themselves. So it just is a matter if you want them to assess it or if you're going to refile yourself. Most people are just going to want them to redo it because it's a lot easier. This person's saying I have a son who is 20 years old with autism, still in my care, and go to college at SAIT for my son still eligible for the disability child benefit. Um, hmm. I think the children still gets the child's benefit. Well, no, I don't think I know. I was thinking of something completely different here. So this is the CPP children's benefit. So yes, as long as the child is still in school, it doesn't matter that the child has autism. That was throwing me off here. Um, as long as the child is still in school, you can still get the money. Yeah, I reread it. I misread it too. Yeah, this is correct. And I get what Buckets is saying here because I misread it as well. Yep. So as long as your children are still in school, they can continue to get the children's benefit up to age 25, but they have to be, I believe it's full time in school, and but you just have to submit proof of the enrollment. All right, let's grab another one here. Let's see. Um, looks like the same thing. So this is the children's benefit. It's called the disabled contributors. It's the same thing as the CPP disability benefit. This person's just wondering what should be done with the money. Up until the age of 18, the parent can use the money for the child's care. After 18, the money goes to the child and they kind of use it as they see fit. Yeah. So again, Caro for the win here. It's meant to put food in their mouth. Once they're 18, they still get it if they're in school and it will be paid directly to the kid. Yeah. And this person wanted to know what about the kids owing taxes? The kid won't owe taxes unless they earn more than the basics exemption. There we go. Says this person, sometimes you get interesting things on here. Yes, if your child is working part time, then when they declare their taxes, they also need to declare the CPP child benefit. That's interesting. So it does get taxed. People are saying it does get taxed to the child. I've just never followed it through to see how the taxes go, but it makes sense if it's paid directly to the child that they would get taxed on it. Yeah. Most kids in school are not going to earn enough that that their CPP disability benefit plus their income is going to put them into a tax above the basic exemption, but it's possible they could if they had depending on their income. Okay. All right, that's enough of that. I think I'll double check here. I'm going to do a quick search just to see if there's anything new with. Is there anything new? Ooh, getting kind of dark in here. Oh, I forgot my lights. That's what's going on here. That's what's going on. I forgot my lights. Let's do a quick look. Let me see if there's anything new on the Canada disability benefit. I know we have here. I'm getting away from my mic here. I know people are constantly asking, is there anything new with that? I'll just do a quick look here. Nope. Looks like nothing new. Still nothing new. So we're still waiting to hear how that application process is going to work. All right. Well, that's going to be it for today, folks. I'll see you back here tomorrow when we do our question and answer live. If you have some questions you want to ask live on the air, you'll be able to phone in and I will be able to answer them for you. Other than that, I hope you have a good weekend. I think I'm going to be taking Friday off again. Won't be doing a show this Friday. So um, I hope you guys will have a good weekend, but I'll see you back here tomorrow first. Take care.